Alex Warren Green on behalf of Ms. Bonkachan. Please state your name.
Julie Bonkachan.
Your Honor, this time we're asking the court to set the matter for a preliminary examination. If I may address bond.
Sure.
Thank you, Your Honor. Ms. Bonkachan was last before the court a week ago. That time she was remanded for bond violations. I believe she had 2 missed tests and a positive test.
That and lying.
Of course, Your Honor.
Okay.
And that's
Okay, go ahead.
Ms. Bonkachan does wish to apologize to the court today for being dishonest at that time. She's assured me that she will continue testing, that she knows what she needs to do, that if her phone wasn't working or anything else like that, that's really not an excuse to miss testing. She's fully employed, sorry, Your Honor, and cares for her 2 children. Right now, her 2 children are living with her sister, so we're just asking the court to consider reducing her bond.
Let's pause here because what the defense is asking for sounds reasonable at first. A working mom, caring for 2 kids, trying to comply. But this is where courtroom drama meets cold facts, and the judge is about to pull the curtain back.
Right now, she's held without bond or a personal bond.
I'm sorry.
Go ahead.
If her children are living with her sister, then I'm really concerned because I do have note that she called the victim 41 times. And my understanding was the only reason to
Excuse me?
contact the victim was to have contact with the children. So if the children are not with the victim, then I am concerned.
Okay, hold on. So the Daniel Gray, I have listed as the victim.
Correct.
Found the street.
There is contact allowing for conversations about the children. That was my understanding of the bond conditions. So if the children are with her sister, I see no reason for her to have contact with the victim.
Well, the conditions that I have is that the only communication that would have been allowed with the victim regarding the children would have been by text.
There have been 41 phones.
Here's the twist. The entire justification for those calls, keeping in touch about the kids, falls apart. The kids aren't with the father. They're with her sister. And when a judge sees inconsistency like this, it doesn't just raise eyebrows. It raises legal consequences.
That's 41 calls this week?
41 calls since she's been taken into custody. That
Oh, dear God.
Some conversations, we never argued or anything. It's just straight about the kids.
Counsel?
Well, Your Honor, that's the first I've heard of it. I don't think
Do
Ms.
you
Warren.
want to talk to her about it? Because, I mean, here's the problem. Problem is her bond conditions are that she could only communicate with that individual by text. I realize being in custody, that may not be able to happen. But then the only communication that can occur via text is it has to be regarding the children. You got 41 calls to this person. I have 41 calls to this person and then find out that the person that would be caring for the children is not this person, is not the victim. That's a problem. Just on the face of it, it's a problem.
I understand that, Your Honor. And I know Ms. Bonkachan's primary.
I hate to do
concern
this
is
to the
for
sheriff's
children.
department. Why don't, because theoretically, she may have been released, but this throws a whole new light on everything because she hasn't been doing any, I mean, she's just making her own rules, which is really part of the problem with how she got herself in, outside of lying to me. And now, and not following her bond conditions, and then now I've got another one, potential.
41 calls from jail? That's not a parenting conversation, that's a pattern. And the judge knows it. This is where we see the emotional cost of ignoring bond terms. What was meant to be a small window for co-parenting has now turned into a major violation.
So let me do this. The sheriff's office would be so kind. Take her back. You might want to talk to her because otherwise. Case people versus Buckington.
Assistant Prosecuting Attorney Morgan Barroso, on behalf of people.
And Alex Warren Green on behalf of Ms. Vaughn Fichan. State your name again.
Julie Bompachan.
Thank you. Your Honor, I had an opportunity to speak with Ms. Vaughn Fichan. I addressed the phone calls with her. And, Ms. Vaughn Fichan doesn't deny calling the complaining witness in this matter. I don't know the subject matter of those calls, but what Ms. Vaughn Fichan tells me is that subject matter, when those calls are reviewed, is going to come back largely regarding the children, and that the discussions they were having were about the children. The children are staying with her sister while the complaining witness is working. That is filling the void left by Ms. Vaughn Fichan being in custody. Before Ms. Vaughn Fichan was in custody, the children would stay with her while the complaining witness worked, and when he wasn't working, would stay with him. So that arrangement is the same. It's just that Ms. Vaughn Fichan's sister is taking care of the children while the complaining witness is at work. So again, I don't know the subject matter of those calls. What Ms. Vaughn Fichan tells me.
And you don't know from the people, you don't know the subject matter of the call.
Your Honor, when I saw 41 calls, I was under the impression that they would be related to the children, but that doesn't eliminate my concern.
I know.
And I'm also concerned at her representation that is largely related to the children, which to me leaves room for an understanding that there's other things being discussed as well.
And Your Honor, what Ms. Vaughn Fichan tells me is that none of their communications regard the case. None of them are communications regarding what the complaining witness should do or can do or may do. It's nothing to do with that.
Okay, I get that. But all that does is stop additional charges. Right?
Of course.
Or that goes to whether or not there would be.
The defense is still clinging to but it was about the kids angle. But the damage is done. The judge doesn't just doubt her now. She flat out doesn't believe her. And in a courtroom, trust is everything. Once it's broken, it rarely comes back.
And here's my other problem. And this is the problem that people have when they come before me and they lie. You lie to me, then it's hard for me to believe anything that you're saying. And so if you're saying you're calling regarding the children, are there calls to her sister at least?
I have not checked. We don't have the sister's phone number because it's not in the police report.
Counsel, how soon can you get the phone calls to?
I'll send an email request right now.
Pardon?
I will send the email request right now. Usually they get released within a day.
I'll adjourn our probable cause out 1 week to the 14th. 9 a.m. Get the calls over. At this point, I'm not going to set it for exam. At this point, what I'm going to do is then let's do it this way. You wanted it set for exam, correct?
That is correct, Your Honor.
All right. I'm going to give you a probable cause date on the 14th to try to address her bond to see if we can get her out of custody without some other thing happening. I'll set her preliminary examination. I'll set that for the 26th, 2024, 9 a.m. That will be before me. Next week, though, we'll address her bond after you've had a chance to listen to the calls. And right now, she has no way to communicate about her kids at all. because she was doing it by text before.
That's right, Your Honor.
And at least pending the hearing next week, her phone privileges, defendant's phone privileges in their entirety are revoked.
And there it is. All phone privileges revoked. A mother who once had the court's patience now has only restrictions. This wasn't just about 41 calls. It was about lying, manipulating the rules, and disrespecting the process. The judge doesn't just punish. She sends a message, loud and clear.
Just keep making it worse.